there we go. Good afternoon, everyone. Welcome back. We had a great morning session, and our afternoon session. This particular session, we've got a couple of luminaries from the intellectual property field, and one young upstart. We're going to have the same kind of structures we had in the very first panel. Is that each of these guys are going to give a talk of 15 to 20 minutes, and then we're going to have plenty of time at the end for questioning and answering and critiquing them. And I think we'll likely get some interesting debate going, perhaps even between our panelists. The first speaker is Professor Peter Manel, who's a professor of law at University of California, Berkeley School of Law. He's also the director and co-founder of Berkeley's Center for Law and Technology, which has been a great mover in the area of the law's reaction to technology over the past 15 or 16 years. Peter is one of the, right, if you look at his degrees, right, there are quite a few of them, and he's also, right, they go all around. He has a degree from Harvard, Stanford, and MIT. He may have multiple degrees from at least one of those schools as well. Like Professor Limley, Professor Manel has written some of the most influential articles on in the area of intellectual property of anyone that's around today in the world. And so we're very fortunate to have him here. Our second speaker, I'll go ahead and introduce him, is Professor Ryan Baca, who is a professor at the university, a new professor at the University of Akron in Ohio. Ryan is a Mizzou law graduate from, I think, 2004. And I was asking around faculty for a few stories, and there were a few I can't tell. One of them, Professor Fryermuth mentioned that. So this was in 2001 when students were beginning to have these bulky laptops they were bringing to class. But instead of bringing a laptop, what Professor Baca brought was his tiny Palm PDA with his roll-out keyboard that Professor Fryermuth called his Lilliputian keyboard, and so that's how he's still known at the law school. Professor Baca is so he's continuing to work on some interesting models for for the Federal Circuit's role and other courts' role in essentially setting policy, and they're kind of unique models, and I think they're really interesting, and so I'm excited to have him here and talk today and have him return to Mizzou. Our third speaker today is Professor Mark Limley, and he's well known as probably, right, so I did a count on this, and by my count, he's I think the most cited patent law scholar in the U.S., and he's written hundreds, well over 100 law review articles. That each one of them is interesting, and when I was in law school, they were at least very influential to me in learning how I think about the law. He's at times controversial because he doesn't necessarily take the same stand as most patent holders, but at other times he's controversial because he doesn't take the same stand as those who would weaken patents. In addition to being a professor, Mark Limley is also one of the leading litigators in intellectual property law litigation in California, and he's been cited in kind of numerous rankings of the top litigators in California and across the country. And so his experience is interesting in that he's teaching it by day, and I guess by weekend and night, and other days he's litigating it. And so I'm very happy that Mark made it as well. Let's go ahead and get started.
Okay, thank you, Dennis. I'm going to start sitting down. I'm eventually going to use some PowerPoint slides. But in the spirit of this morning's talk, I want to say that the paper is currently on track 3. And I'm trying to move towards track 2. And we're going to have to work some of that out. I do have some track 1 applications right now. My youngest son applied to college this fall, and that's the reason this project is on track 3. Because his applications took priority over getting this kind of work done. But I want to read you from sort of the beginning of the article, and then I'll try to give you some of the conceptual layout. When Congress created the Court of Appeals for the Federal Circuit 3 decades ago, legislators focused on the need to reduce forum shopping in patent cases and interpretive confusion that resulted from multiple courts of appeals. Although the House report envisioned the judiciary reform legislation establishing the Federal Circuit as a partial antidote to a perceived crisis in U.S. productivity, few saw consolidation of federal appeals as playing a significant role in shaping the content of patent law. And as Dennis has focused this conference, that is what people are talking about today. But I'll mention that Senator Leahy, who today is chairing the relevant committee concerning patents, then a very junior senator opined that the new appellate court, quote, will not solve any of the substantive problems with our patent laws, but it will go a long way to diminishing forum shopping. So quite an interesting shift over 30 years. I think many people today see the Federal Circuit as deeply involved with orchestrating, guiding the patent system. I think the Supreme Court in the last 15 years has joined as well. And so trying to understand this landscape is, I think, a really important project. And so I'm going to try to sketch out kind of a larger view of this project. I don't know if our slides are present. I think I might have to press the black screen button. There we go. So let me just take you through, and these are not very fancy. I just threw them together quickly, but I wanted to give you a little, give your eyes something to organize as I talk through some of these ideas. So I think that whenever we talk about policy, it's important to be upfront about what we view as our objectives. The easiest way of characterizing the objectives for patents are to promote progress. But as we all know, that's a very open-ended goal. And I think as many people see that as there are interpretations of it. So I want to be upfront. What are my interpretations of how patent institutional players should approach this goal? And I'm going to put them not just as a list, but also in order. I think in order for the patent system to function well, we have to have reliable outcomes from the process. And the process begins at the Patent Office. It may not fully resolve until we have litigation. But ideally, the Patent Office would come pretty close in a lot of cases. How we measure quality is I think, very much open to debate. But how could we possibly think that the system is promoting anything if we don't believe that there are good grades handed out by the Patent Office? Just think about our students coming out of law school. Not that our grading system is perfect, and I often have to call up a judge and say, this student didn't do well on the exam, but they are a great candidate for this clerkship. And I believe that because I don't have such faith in my exams. But I do think that ideally our patent system would create confidence. Secondly, there are a whole bunch of people who care about what comes out of the Patent Office. Any investor and any entrepreneur and any inventor wants to be able to judge the landscape. I don't want to build something on real estate that's owned by someone else. And so an ideal patent system is going to provide notice and clarity to others, because those others can devote their resources elsewhere. I'm not going to make a big investment if someone already has a strong claim, or I'll be able to negotiate with them up front. But in an ideal system, you don't create first and look later. You look first, have some sense of what's available, and make some choices. The patent system doesn't operate that way. Mark has written a lot about that, And for IT, you won't find anyone who approaches it that way. And that's, I think, a problem. Third, and somewhat inconsistent with at least number one, we want the system to provide relatively rapid determinations. And that's going to come at a cost. I mean, we can make 1 and 3 fit together if we're willing to spend more money. But where does that money come from? Fourth, patents are viewed as a one-size-fits-all instrument. But there's no good economic reason for that. Patents are dealing with a very heterogeneous goal, trying to promote progress across many different fields. Some fields have shorter time frames than others. The remedies have to be proportionate to those values. And so we would ideally like the patent system to have some sensitivity to what is appropriate for different areas. Not something that can easily happen within a uniform system, but as Mark has written, there are more subtle ways of achieving those ends. Okay, so let's think about the institutions that do patent policy. I'm going to say that Congress is most important. It doesn't often act. From a political economy standpoint, it has been pretty much at a stalemate. But I think, as David Kapos talked about this morning, there seems to be recognition that there are things that they can do. And, I think that they are setting the tone of our patent system at the structural level. I don't think that they should be fine-tuning to the degree that perhaps the Federal Circuit is capable of doing. But to the extent that we're going to make some significant changes in the system, they have to come from above, and that's Congress. The Patent Office, as we heard this morning, can and does play a very important role, and I think we're going to see a lot more dynamism. When the digital age started to unfold, I wrote a paper about the copyright system, and one of the predictions I made in the late 90s was that the copyright system would move away from a regulatory model, away from a property model towards more of a regulatory model. And we see that in many respects. The Library of Congress, for example, is doing rulemaking on whether there should be exceptions to the anti-circumvention provisions. And I think we're getting a sense that these rights in this fast-paced digital environment have to be thought about using a variety of institutions. The patent system, at least based on what I heard this morning, is moving in that direction. I think people there are paying more attention to what can the issuing agency do to make the system more responsive and more effective. So the Patent Office is a big part of the policy landscape and has a very distinctive role. And then we have the court system. The Supreme Court, I think, is largely an error correction system. They would rather not deal with patents, but they have, over the last decade, taken a much more active interest, and I think they will continue to do so, given the importance of patents in our system. The Federal Circuit, they are, although when you talk to people there, they'll tell you that they do other things, but I think they are really a patent court, and they have come, especially Judge Rader, come to see themselves as having a pretty active role in trying to make sure the system is functioning pretty well. Obviously, the district courts are very important, but they see patents episodically, with the exception of Eastern Texas and Delaware. Whether we want that is a question that's going to play out over some time period. But I don't think we can see the district courts as playing as direct and overt a role. Occasionally, they see something dysfunctional, and they will be experimental. But I think the Federal Circuit is the place where that tends to happen. But the district courts have been very important in the sense of generating local rules and trying to improve the patent system from a ground up. Let's try to process cases more effectively, more consistently. And so in both the patent local rules and some model jury instructions, we see innovation going on and policy making. It's not overt policy making, but it's policy making that we hope is improving the quality of adjudication, which is very important in a system like ours. So how can we, I want to focus my remarks on the Federal Circuit, given the nature of this conference. patent doctrine is the most obvious place that patents play out. And so we would obviously demand that the Federal Circuit be faithful to the Constitution. That's the highest directive. And also to legislation, the statute itself. But here's where I think we're potentially getting into a very difficult situation. If the Federal Circuit is going to play a role beyond simply reading statutes as a dictionary definition, then we're going to have some breathing room within the doctrines. The law itself is very terse. We're all familiar with that. The core provisions are a sentence or two sentences long, and the courts have always played a very big role. But I want to call your attention to a passage from the Bilski case, because I think to the extent the Federal Circuit can play an active role, we need to be mindful that textualism is, in some ways, a very severe constraint on that role. So, Justice Kennedy says, any suggestion in this court's case law that the Patent Act's terms deviate from their ordinary meaning has only been an explanation for the three historical exceptions: laws of nature, physical phenomena, abstract ideas. The court has not indicated that the existence of these exceptions gives the judiciary carte blanche to impose other limitations. And then what Justice Kennedy does is he pulls out a 1954 Webster dictionary and says, well, the definition of method in 1954 is what we should use as our measuring stick for deciding what the scope of the patent system is. Now, I think Justice Stevens does a much better job of explaining history. Whether or not you agree with him, whether or not you share his policy views, he's capturing a sense in which the patent system has largely been developed in the courts. And that's something that I think is important that we confront. When you look at statutory interpretation, there are statutes, like our main intellectual property statutes, the Sherman Act, that date back to a period when Congress wrote tersely and the courts filled in the details. In the modern era of environmental statutes, the Tax Code, Civil Rights Act, the Digital Millennium Copyright Act, we see very detailed statutes where Congress is constraining the judiciary. But that's just not true of much of the patent statute. And if Congress were to try to do that, I think the courts would be required to be faithful to it. But right now, the system is a common law statutory interpretation hybrid. And so if we approach these terse provisions with the kind of breathing room that has historically been there, I think we get a more dynamic system. We have room for judges to play an active role. If, though, we follow Justice Kennedy's lead, or really Justice Scalia's lead, we wind up with a statute that Justice Learned Hand would have characterized as a fortress of a dictionary, that we're locked in by historical dictionaries as opposed to this much richer context. And I think that context is what has given the patent system its ability to adapt and evolve. And so if we're going to have rapid technological innovation, we're going to need that breathing room. Congress, as we see, is not able to act very quickly. And a lot of these doctrines do, I think, provide a good, they have a common law character that we can build on. If we go the route of textualism, strict textualism, then we're going to lose that breathing room. So what does this all mean? I think that we want to go back to the history and try to understand the principles that underlie the system as we interpret the statute. We're going to have to fill gaps. We're going to have to evolve the standards. And we're seeing that, I think, in much of what the Federal Circuit does, even though they don't say it so clearly. Secondly, and this is something that goes outside, a lot of what I've said, I think, is consistent with what Mark and Dan have been writing about, saying that the Federal Circuit can meld the patent law in various ways. But I want to add to that a friendly amendment that patent case management is an important other area in which the courts are really the dominant actors. And the Federal Circuit has been relatively hands-off, and I think that makes a lot of sense. But there are areas in which that's going to be important. claim construction. Do we really want to have de novo review? The Federal Circuit gets to decide that, and the Supreme Court will probably back them up. The fact-law distinction. It's very hard to know what is a jury or a judge issue. Why is the doctrine of equivalence not a policy issue? I don't really understand why you would have a jury decide that. It really requires a sense of understanding of how the patent system functions. I don't know that a jury instruction should give you the answer. We have that same issue right now in 103, non-obviousness. Why should a jury decide the ultimate question? It's a very rich, complicated policy issue. And at least in the Northern District of California, the judges recognize that, and they're developing rules to try to limit the jury to the forensics and have the judge, someone who's in a position to weave together those principles, make that determination. And if we don't do it that way, how can the Federal Circuit possibly do their error check? If they don't know what the facts are, they can't easily determine that. So if you give the jury a black box, is it obvious, is it not obvious, you have no way to review that. Venue. This is a very important policy lever. I think everyone is familiar with this. Judge Rader is clearly moving the court towards careful oversight of that question. The Daubert question has come up in the damage area. Mark's going to talk a little more about that. The Unilock case is very much a policy case. The Federal Circuit has said you can't use the 25% rule. You can't use the entire market value rule. Now, whether or not you agree with it, it's clearly a policy judgment being exercised by the court. And what guides it? It's not the statute. And I think they're doing this based on some sense of how the patent system is functioning. The willfulness doctrine went through a similar reworking over the last few years. So the last piece, and I'll end with this, I think the Federal Circuit has a very important policy role in a pedagogical function. You have hundreds of district judges who don't have very much training in patent law. And the Federal Circuit needs to be very mindful of that. And they've done this, I think, increasingly. We'll hear from Ryan. I mean, the en banc process is a way of trying to provide better guidance. And that's going to be very important when district judges who don't have experience have to interpret the law. And also, the practice of having district judges on the Federal Circuit has been, I think, very important to spreading the word. And Judge Rader's sitting in the district court has also a benefit, and now Judge O'Malley is going to be there. So I think we can see the policy landscape as being quite broad, quite variegated, quite interesting. And, you know, it's better that we recognize these features and talk about them than to act as though Congress makes policy and the court interprets. It's really much more of a dialogue. It's more of a dialogue between the institutions. The other interesting thing is that there's a feedback effect. When the courts pushed the obviousness doctrine too far in the 40s, Congress wrote 103. And so that's the kind of, I think, healthy process that we get in our republic. So I'm going to leave things there, and I look forward to your questions and comments.
My research on the Federal Circuit focuses on what happens when the court sits en banc. And Beth Winston, I heard from earlier, we were chatting one day in early January about this symposium, and one of the topics that we started talking about was the Federal Circuit's forthcoming en banc opinion in Terrasens on the issue of inequitable conduct. And as we discussed, I began to think that the Federal Circuit has been hearing a fair number of cases en banc over the last several years. And I thought this was kind of interesting, so I started digging around and looking at some of the en banc opinions and the en banc orders. And lo and behold, what I discovered was that the en banc Federal Circuit looks very much like an administrative agency that's engaging in substantive rulemaking. So what am I talking about? Well, let me first give you a kind of brief roadmap of where I'm going for the next 18 or so minutes. So first what I'm going to do is describe the en banc Federal Circuit in terms of how it causes a case to be heard en banc, how often that occurs. Then I'll describe what the court's doing when it orders a case to be heard en banc, and how this makes the Federal Circuit look an awful lot like an administrative agency. And then I'll conclude with some concerns that we might have about the Federal Circuit's en banc practices, and why, notwithstanding these concerns, it's not so bad, at least until some political or structural changes occur. So I'm going to start with some numbers. So since its creation in 1982, the Federal Circuit's heard 44 cases en banc. And of those 44, it's actually decided 42 of which we're still waiting for. Now, when I looked at it in terms of the total number of cases decided by the Federal Circuit, this is only 0.10% of the cases, 0.9% if you only count the ones that were decided. But remember, the Federal Circuit, it doesn't just hear patent cases. In fact, only about a third of its docket constitutes patent cases, ranges from 28 to 32% over the last 5 or so years. So when we discount for this, the percentage of cases heard and decided en banc rises to 0.32% and 0.29% respectively. Now, to put this in perspective, I calculated the percentage of cases in the other federal circuits, the other courts of appeals, from the time period of 2000 to 2009. The average in those other circuits was 0.11%, ranging from 0.01% in the Second Circuit to 0.24% in the Eighth Circuit. Now, of course, the number that I was speaking of before for the Federal Circuit, 0.29, that ran from 82 to 2010. So what I had to do to make sure I was comparing apples to apples is I ran those same numbers from 2000 to 2009. And it didn't really make a difference. The Federal Circuit was deciding 0.25% of its cases en banc, which is, of course, over twice as much as the average of the other circuits, and even higher than the highest of the Eighth Circuit at 0.24. So based on this analysis, the Federal Circuit appears to be deciding more cases en banc than any other. So I thought this was interesting. But something else that was interesting was that of these 44 cases that were heard or ordered to be heard en banc, I could confirm that at least 21 of them, so at least 48%, had been ordered sua sponte. So at this point, we have the Federal Circuit being a very active court with respect to hearing and deciding cases en banc, and then about half the time it's deciding these on its own court. So all this is pretty interesting, but not really cause for concern. What's more striking about the Federal Circuit's en banc practice is the number and scope of questions that the court undertakes to address when it sits en banc. Now, of the cases that I was able to get documentation on as to the number of questions that were asked, it averaged 3.4 questions per case. And if we look over time, we actually see that this number's been increasing. 69% of the questions were from within the last 11 years, averaging 4.2 questions per case as well. But it's not just the number of questions that's really surprising. It's the scope of the questions. So the en banc Federal Circuit seems to be trying to tackle the big questions. Is there a written description required in the area? Or when the doctrinal question is a little narrower, how should an equitable conduct work in their sense, the court's questions really try to cover all the details within that specific area. So this, in combination with the rate of en banc hearings and decisions, it might cause some people to become uncomfortable. The Federal Circuit is not just deciding the case before it, but instead it's making broad and sweeping pronouncements about patent law and its rules. Now, the final practice of the en banc Federal Circuit that I want to draw your attention to involves the use of amici in the briefing stage of the cases. So of course the federal rules of appellate procedure permit amici to file briefs, but in order to do so they need to seek leave of the court or get permission from the parties. And the Federal Circuit certainly uses amici. In fact, many of the recent en banc cases, the orders that order the case to be heard en banc, they expressly permit amici to file briefs without leave of the court. And in some cases, the Federal Circuit actually orders or invites the PTO or the United States to actually submit amicus briefs as well. So I did, just to compare to other circuits, I did a quick survey of what the other circuits were doing, and I didn't find the other circuits using this type of language in their en banc orders. Specifically invited amici to file briefs without leave. Of the few courts that actually, a few orders that did mention amici, they actually specifically required them to seek leave. So what does any of this have to do with administrative agencies and substantive rulemaking? So as Peter pointed out, Congress frequently delegates its responsibilities to flesh out the details of various statutory schemes that it sets out and really develop policy in a certain field. And many times it delegates these responsibilities to agencies. And Congress does this, of course, when it doesn't have the expertise or the time to set forth the details, or it doesn't have the foresight to address future issues. Lots of examples of this that we come up with. The Patent Act is, of course, very similar to these statutes, where, in terms of what needs to be fleshed out. Although, again, as Peter mentioned, there's specific instances that are some parts of the Patent Act that are fairly specific. Most of it is written in fairly broad terms. Obviousness, patentable subject matter are two that come to mind. But all in all, I think agencies probably do a better job than Congress at fleshing out the details and setting policy in a certain industry or field, because the agency specializes in that area and knows the needs and wants of the various stakeholders. So what do the agencies need to do in order to flesh out the details? So of course what they need to do is follow the procedures set out in the Administrative Procedures Act, issuing notice of proposed rulemaking, receiving and considering comments on the proposed rule, and issuing, of course, the final rule that incorporates a statement of its basis and purpose. So now we're trying to see how this kind of all fits together. Besides setting forth broad rules or trying to deal comprehensively with a particular doctrine, and consequently setting patent policy, which looks like what agencies do when they flesh out the details of congressional legislation, the Federal Circuit also seems to be following the notice and comment procedures when it hears a case en banc. So when it issues its en banc orders, it's advising the parties and the interested public that it'll be undertaking efforts to set a rule or rules in a particular area of patent law. And the en banc orders, of course, they set the time, place, nature of the proceedings, when it invites the parties and the amici to file briefs, it gives a briefing schedule, set the date for oral arguments. And with respect to the comment part of notice and comment, as I previously discussed, the en banc Federal Circuit gives the parties and the amici plenty of opportunity to participate in this rulemaking procedure. Permits them to submit reviews and suggestions about the possible rules, and even in some circumstances it allows amici to actually or argue in oral arguments. And then finally, the agencies, they need to publish the rule in a concise general statement. This procedure, of course, largely followed with the en banc court hands down its decision. Of course, some of you may disagree with the concise part of that, but we'll get into it. So, in sum, the act that the Federal Circuit is fleshing out and setting policy in is similar to many other statutes that Congress has delegated substantive rulemaking authority to agencies in. And moreover, the en banc Federal Circuit seems to mimic the procedures that administrative agencies use when they promulgate substantive rules that have force and effect of law. So now the question becomes, is this a good thing? Should the Federal Circuit be setting policy in this way? And the strongest objection to the court doing this is really a separation of powers argument. So the courts decide cases, they don't set policy and promulgate rules. That's the job of Congress and or administrative agencies. And this is a valid concern, one that I'm sympathetic to, but at the same time, I don't live in a fantasy world. We know the courts, especially the circuit courts, set policy all the time. Think back to then Judge Sotomayor's infamous talk where she said, no, we don't set it, and everyone laughed. But I don't want to completely discount the separation of powers argument, because, as I said, it is a valid concern, but we do need to look beyond it when we evaluate this situation. So another objection or concern to the Federal Circuit's en banc practices is that, unlike agency substantive rulemaking, there is no meaningful backstop of judicial review. So when an agency promulgates a rule, interested parties with standing can challenge the rule in court, make sure the agency hasn't overstepped its bounds. But we don't really have that when the Federal Circuit sits en banc. Sure, of course, we have the Supreme Court, but as Peter mentioned, only here's a small number of patent cases every year. And so the separation of powers and lack of review objections seem to be fairly strong to the en banc Federal Circuit setting patent policy and crafting these types of broad rules. Nonetheless, there's still a need for somebody to set patent policy. And there's a few contenders out here. Not here, out there in the world. Maybe there's some here too as well. Yeah, some are here in fact. And so what I'm going to do is I'm going to conclude by discussing these alternatives to the en banc Federal Circuit and see if they can or should replace or in fact complement the Federal Circuit. So from a separation of powers perspective, Congress, of course, seems like the obvious choice. I don't have much faith in Congress, though, stepping up to this challenge. Patent reform is on the table again this year, I think for the sixth time in so many years. And although the bill did just make it out of committee a week or two ago, there's still a few steps along the way before it becomes law. And even if it does succeed, the current patent reform bill, it only goes so far. It does make some major changes, first to file, getting rid of best mode as a grounds for validity, but there's still much work that needs to be done and a lot more policy decisions to be made. So our next potential body is the Supreme Court, certainly showing more of an interest in patent cases recently, but again, probably not the most effective body, given that it only hears 1 to 2, maybe 3 or 4 in a good year. And like Peter said, the district courts perhaps shouldn't be forgotten. Of course, their problem, like the Supreme Court, is that they don't hear too many patent cases, and of course they also have the structural problem of not being able to bind the Federal Circuit or Supreme Court. So then, of course, we have the PTO. Now, this seems like a good idea. They have expertise in patent law. They are an agency that interprets patent law and administers it. So maybe they'd be a good contender. Unfortunately, the PTO doesn't have substantive rulemaking authority. The courts have consistently held this, and as a result, its rules don't have the effect of exclusive law, just persuasive authority. But it's not a complete loss. The PTO does issue guidelines that the Federal Circuit does seem to take seriously. So at the end of the day, we're left really with the Federal Circuit. And unlike the Supreme Court, the district courts, the Federal Circuit's docket is comprised of several hundred patent cases a year, giving it the necessary expertise. And unlike Congress, the Federal Circuit is willing to direct patent policy. But perhaps the most compelling reason for being okay with what the Federal Circuit is doing when it hears cases en banc and decides them en banc is that it's really using the two most admirable characteristics of administrative rulemaking that we like is expertise and the opportunity for the stakeholders to be heard. That's exactly what they do when they're engaged in this en banc practice. I've now run out of my time, so I'll end there. Thank you.
So we're here at a conference talking all day about the Federal Circuit, and you're listening to a bunch of law professors. And not one of them has said, oh my God, the Federal Circuit is screwing up Doctrine X. I think that's my job. So let me say, oh my God, the Federal Circuit is screwing up Doctrine X. And in particular, the doctrine I want to talk about is ongoing royalties. So Section 284 of the patent statute provides courts award damages, quote, adequate to compensate for the infringement, but in no event less than a reasonable royalty. And traditionally, the court has done what courts generally do in calculating revenues. They've treated damages as backward-looking. We award damages for past conduct that can be remedied in no other way because it's already passed. And going forward, we grant injunctive relief. After eBay, though, that's not necessarily going to be the case. Right? After eBay, about a quarter of all patent cases lead to a denial of ongoing injunctive relief. If you're a non-practicing entity, it's more like virtually all of the cases leading to a denial of injunctive relief. Well, if there's not an injunction, then what? The virtually unanimous answer in the district courts has been to award some sort of ongoing royalty. It's not that the defendant gets off scot-free for future infringement because we denied an injunction. They're going to have to pay. They're going to have to pay some kind of an ongoing royalty. But this raises several issues. First, is there actually legal authority to grant ongoing royalties at all? Second, who decides what the ongoing royalty should be? And third, how do we calculate that ongoing royalty? The courts have largely ignored the first two of these questions, and while they have paid attention to number three, I'm going to suggest that they've gotten it wrong. So let me start with number one. Is there actually authority to grant ongoing royalties at all? Thomas Gomez at Lewis and Clark Law School has a provocative article in which he's argued that courts have no authority to order ongoing royalties either as a matter of law or as a matter of equity. His basic argument goes like this. Well, English equity courts in the 18th century didn't grant ongoing royalties. They split law and equity. Law dealt with damages. They either granted injunctions or they didn't grant injunctions. And because they didn't grant prospective financial awards, under some fairly restrictive current U.S. Supreme Court doctrine, notably the Grupo Mexicano versus Alliance Bond case, U.S. federal courts don't have any equity powers that the British equity courts didn't have back in the 18th century. And so you can't expand those categories of equity relief, so no equitable relief power. Well, what about damages awards? Here he says, damages they've got to be past-looking, they can't be forward-looking. And he points to cases interpreting not the patent statute that governs normal infringement, but Section 1498 that governs suits against the government, which has somewhat different language, but despite calling for reasonable and entire compensation, has been construed by the Federal Circuit to apply only to past damages. And so Thomas Gomez concludes the only thing you can do if you're denied an injunction is file successive lawsuits every year or two and get additional little increments of damages, kind of Zeno-like, right? Smaller and smaller increments in each different little lawsuit. Now, I actually think you can arguably justify ongoing royalties under either an equity or a law rationale. First off, I think Section 284 can be read to give forward-looking damages in appropriate circumstances. The Supreme Court in the GM versus Davex case read that statute as intended to, quote, afford patent owners complete compensation, unquote. And I think arguably you can say that if I'm selling an identical product tomorrow to the one I sold yesterday, affording me complete compensation in the absence of an injunction requires me to pay not only for the thing I sold yesterday, but also for the thing I sold tomorrow. Now, of course, if you change your product, things get more complex, and at some point you have to revisit that issue. And it's worth noting that we grant forward-looking remedies in other circumstances. We grant them even in patent law in the context of post-verdict interest. that it will pay you money for things that happen after the verdict on a calculated predicted rate. Trade secret law expressly grants continuing royalties in circumstances where it doesn't feel an ongoing injunction is appropriate. And indeed, in real property, we grant damages for ongoing trespasses in the case of continuing trespass, a trespass that we know is going to go on in some traditional way. Second, I think you could also justify ongoing royalties as a matter of equity. It's true that the British equity courts didn't grant ongoing royalty awards in patent damages cases in the 18th century because the issue never came up. It's not as though they refused to grant them, it just never arose. But they do grant and have traditionally granted things like accountings for profits and constructive trusts, which indeed 100 years ago in this country were the primary form of monetary compensation that patent owners got. Rather than a statutory damages award, you got some sort of a constructive trust award. And I think it's perfectly reasonable to say that this is a category of equity power that the courts have always had and that could apply to grant an ongoing royalty. Well, at this point you're thinking to yourself, really, who cares? Right? Maybe of interest to law professors, but in the 18th century English equity, come on. In fact, though, I think it matters what the source of authority is. Judges have been setting the ongoing royalty in virtually every case in which the district court has had the issue. But whether the judge actually has the power to do so depends on whether we think this is a question of law or a question of equity. If we think that this is a legal question and we're interpreting Section 284 of the Patent Act, then the Seventh Amendment requires that juries, not judges, set the damages award. And that would be true of the ongoing royalty as well as the past royalty. Now, that's not what happens in the district court. It has invariably been the district judge who's given the award. Maybe that reflects some unanimous and unstated judgment that this is in fact an exercise of our equity power, not of our legal power. More likely, I think, they just haven't thought about the question. But I think we do have to think about the question because it's going to matter whether I, as a patent plaintiff, can say to the judge, hey, I have a right to have a jury determine the ongoing royalty, not you in your judicial capacity. Now, there are some practical reasons, usually related to timing, why we might prefer judges rather than juries to set some new ongoing royalty award. Right? By the time we decide that an injunction is not appropriate, the jury has often gone home, so we got to worry about the problem of how do we get the jury to make this determination if we decide that they are in fact required to do so. And that leads us to question number 3. How is it that we calculate the ongoing royalty? Now, you might at this point throw up your hands and say, well, we can't do it. We're predicting the future. How could you possibly calculate what damages would compensate me for future acts of infringement? And it is the case that there's a certain amount of speculation that goes on in an ongoing royalty setting. But there's a certain amount of speculation that goes on in trying to predict the but-for world that would have existed in the past if the defendant hadn't infringed too. We've got speculation in damages awards. It's just one of the things we have to live with. And the fact that it's hard doesn't mean, I think, that we don't have to do it. Now, the good news is we have a useful piece of information. In fact, I'm going to suggest that we have a determinative piece of information that helps us in setting the ongoing royalty. A jury has just told you what a reasonable royalty adequate to compensate for the infringement that these parties would have entered into had they known the patent was in fact valid and infringed. What do we want to know going forward? Well, we want to know what would the parties actually negotiate in a reasonable world now that they know that the patent is valid and infringed? Those sound like some pretty similar questions to me. Nonetheless, the Federal Circuit, in the kind of 2 glancing circumstances in which they've actually dealt with this issue, have said that the ongoing royalty calculation must be an entirely new calculation, divorced from the past damages reasonable royalty award that the jury has already offered. They have not, however, told us what this entirely new calculation should consist of. So in Case versus Toyota, the district court, the jury awarded a $25 per Prius damages award. District court denied an injunction to the non-practicing entity, awarded an ongoing royalty of $25, just as the past royalty was $25. That went to the Federal Circuit. Federal Circuit said, no, got to be an entirely new calculation. We can't tell you what that entirely new calculation will be, but it's got to be an entirely new calculation, because now we know the patent is valid and infringed. Now, One of the reasons that the Federal Circuit says that in Pace is we want to give the parties a chance to settle this for themselves. And I'm all in favor of that, although I'm not sure how you would stop the parties from settling this for themselves if they wanted to, right? It's not as though we've got to sort of recalculate damages to start some clock running that actually causes the parties to settle. If they want to settle, now that they know there's been a district jury verdict finding of validity and infringement and is setting a number, they're going to settle the case. And it doesn't matter that we recalculate ongoing royalties to figure that out or not. What happened in Case, the district court on remand said, okay, well, I can't use the jury's award of $25, which was based on some reasonably sophisticated economic testimony. What else have I got? Well, I know I can't use all of the reasonably sophisticated economic testimony because that just leads me right back to the $25. I'll use the 25% rule of thumb. And so the judge uses the 25% rule of thumb, awards a $98 verdict. I think the case at that point settled, but of course if it hadn't, if it were still ongoing, now after Unilock, it'd get reversed again, because the one thing we know you can't use in calculating reasonable royalty damages is the 25% rule of thumb. Well, second time this comes up before the Federal Circuit in the Amato versus Microsoft case, the court again says it's an entirely new calculation going forward. Got to figure it out. We can't tell you what the calculation is, but we can give you the following parameters. The plaintiff asked in this case for $2 per unit. And I think it's every unit of office that's sold. The defendants, the jury actually awards 4 cents per unit, 1/50th of what the plaintiff asked for. The district judge in that case said, okay, no injunction going forward, but I'm going to grant a treble damages award going forward, 12 cents per unit, because now you know you are an infringer and so your continuing acts are willful. Federal Circuit says, no, it's not willfulness. Willfulness is not the right question to ask here. It's true you now know that you are infringing a valid patent. On the other hand, and I think the court here has a point, it's a bit odd to say, I'm denying an injunction, defendant, go ahead and continue to sell this product, but I'm going to punish you if you do so, right, by trebling the damages because I want to deter you from doing it. And the court says that's just not the right question. What is the right question? Well, the court says, logically, the damages award should be somewhere between what the jury awarded for past damages, 4 cents a unit, and what the plaintiff asks for, $2 a unit. That's a 50 times range. Somewhere in that 50 times range, with as a floor the calculation that that the jury actually entered into about sort of what would we have done if we'd known the patent was valid and infringed, and sends it back for the district court to do something. I think this makes little sense. We have a jury verdict, which, for all its potential faults, right, is at least an effort by the court to calculate an answer to the very question we want to know the answer to. If the parties knew at the time that they entered into this transaction that the patent was valid and infringed, what kind of royalty would they have agreed to? We shouldn't be ignoring that answer in calculating ongoing royalties. Now, it's possible, of course, that things have changed. Right? One difference is the initial calculus occurs at the initial time of infringement. We might say the ongoing royalty calculation should be measured as of a different time, and maybe now we know more about the value of the product. Though under the rubric of the Book of Wisdom, courts are actually paying attention to all that data anyway. While we pretend that we're deciding this question as of the time of infringement, we are not ignoring post-infringement calculations. We're bringing them in rather than hiding our head in the sand. So we really are asking the very same question. And I think that the fact that we really are asking the very same question, on the one hand, ought to make the ongoing royalty calculation quite easy. Right? Ongoing royalty ought to be the same thing as the past royalty. Now, that probably indicates that judges ought to be engaged in setting those royalties in useful ways. Right? A percentage royalty is much easier to sort of measure for future sales than some sort of calculation made from a lump sum royalty. At the very least, a kind of dollar unit royalty like the one in Pace is a lot easier to measure going forward. But I think the basic question is, as a matter of logic, we probably ought to be done once we've got the initial past-looking damages at work. More than that, I guess I want to suggest that we might even be compelled to do so. So the Seventh Amendment has a clause everybody knows about, the right to a jury trial in questions of law, which includes patent cases. Then it's got a second clause that nobody knows about, the re-examination clause. The second clause of the Seventh Amendment says no fact found by a jury shall be re-examined in any court other than according to the principles of common law, which basically means other than according to our standards of J-Ball, no reasonable jury could have concluded this. I think that if we actually take seriously the Federal Circuit's suggestions that you've got to recalculate ongoing royalties and do something completely different from what the jury told us was the right thing to do, we're not only getting the wrong number, we're probably violating the Seventh Amendment re-examination. So, law professors love to do papers and talks about how, the law creates all these annoying complications that prevent us from doing the right thing. This is not that talk. The good news is we already have the information. We need to make the right decision, and the solution is actually easier, not harder, than what the Federal Circuit is doing. Thanks.
Thanks so much, guys. So I'm off here, but we have plenty of time for questions. I've got lots of questions for this panel, but feel free to raise your hand now. We don't have mics for those of you out there, so you have to speak up. I might start off with Professor Manel, since you were first. This week at the law school, this is kind of capping off a full week of intellectual property events that we've had. On Wednesday, we had Professor Yindu from the Huazhong Institute of Science and Technology in central China. She's a intellectual property scholar at the law school there, and she had some interesting comments. And one of her comments was that she kind of has this belief that, at least to a relative extent, the intellectual property laws in China are well written, well understood, and essentially to the full extent that U.S. has intellectual property laws. Right? They have similar or parallel laws in China, and the problem. Right? There is a major problem, but that's with administration and enforcement of those laws. Right? And it's not the problem of the laws not being there. And I was just thinking in our situation, right, where you had this balance up there of creating laws and then interpreting and enforcing them with the courts and also the administrative agency. What's your estimation of where we have our problem or our highlight here in the U.S.? Or do we have one side that's major issue?
Well, I'm going to sort of maybe go into this academic realm that practitioners resist. But isn't it odd that we have a one-size-fits-all system that is fairly static? I mean, wouldn't we want a system that's dynamic? We wouldn't want a system that is able to recognize differences. Now, there's one really good reason to have the uniformity, and that's because it's very hard to structure government agencies that have to decide among parties, with different things. Uniformity gives us a much better, if David Kaplan has to decide, you're going to get 5 years on this, and we're going to give someone else 8 years, and someone else. I mean, that's very hard to administer. I mean, in an ideal world, you probably would try to come up with systems like that. So we want to have some degree of rigidity and some degree of flexibility. I don't think any patent system would do well to just try to put everything into a very rigid code. And the United States has in some ways evolved towards a system. I hadn't heard it presented until Ryan did, that this really is a regulatory process at this stage, that Federal Circuit is going to hear 3 or 4 cases a year as though it were an administrative agency. But I do think that there is a nice kind of dynamism that we get from this. I mean, why did Unilock come up? Well, I think a lot of people saw a problem, and the Federal Circuit was sensitive to the problem, and district courts weren't good at solving it. The Federal Circuit was better at solving it. So I just think, I don't think any country in the world wants to have a completely detailed system. They want to have an opportunity. The Federal Circuit, as a constitutional matter, shouldn't be there. I mean, I think it does violate certain concepts of our structure, but it is functioning in that way, and I don't know that we could do better.
And that's kind of, I think that leads into Ryan's concept of that in the first Ryan, I know Ryan had some flight troubles and was stuck in Memphis last night, but he braved his way here this morning, so he missed Professor Dolak's presentation. But she talked a little bit about the Theracents case, which is an en banc inequitable conduct case that's pending. And this is paraphrasing her a little bit, but I think she rightfully said something to the effect that it's a fairly narrow fact pattern that the Federal Circuit has taken to question most of the underlying law of inequitable conduct. Okay, and I'm your presentation is kind of very much thought provoking, and it just makes me think. If the court, let's say the court does actually even admit that what they're doing is parallel to what a rulemaking authority would do, and they're taking these narrow fact patterns and making some and turning them into broad questions of policy, do we have a constitutional problem? I mean, for the role of the courts is if they're openly admitting this is what they're doing. Do you think that would be shut down in essence?
I don't know. I think it is a problem. Right?
And I guess there's two. You mentioned separation of powers, and I think there's also the case in controversy. Whether this is still a case in controversy once they turn it into a rulemaking issue versus a decision, versus only a decision of the parties.
Yeah, no, I'm just going to add about the controversy aspect of it as well. It is a problem for both of those concerns, separation of powers and case for controversy. My guess is that, of course, Congress can always step in and legislate it away, but of course the only body that's going to do anything about this is the Supreme Court. But I don't think they want to get their hands dirty with this. They've had a practice, of course, over the last few years of slapping down the Federal Circuit, Bilski, KSR, and the like. But I think that the Supreme Court at least recognizes that somebody does need to set policy. And as I mentioned, if they don't want to do it, Congress isn't doing it, the PTO can't do it. And so they're really left with the Federal Circuit. Perhaps if the Supreme Court wants to sort of, shift Congress's hands or force their hands to setting tax policy, that would be one way of doing it. But I don't know if they're that eager to jump into that mix.
Can I just say on this, I think it's right to say that it has a lot of similarities to an administrative agency, right? On the other hand, the Federal Circuit's going to be deciding these questions anyway. Right? They're going to be, if they're going to change their precedent, they're going to change their precedent. Aren't we better off having them sort of tell us up front, hey, we're thinking about this issue, right? Come in, file amicus briefs, bring us information. I'd rather see informed policy making than uninformed policy making.
Of course, if we allow the Federal Circuit to have this role, that means that it will never be given to patent office. And if we don't allow the Federal Circuit to have this policy role, and we know that Congress is not going to really do this on a regular basis, that gap will at some point be handed over to the Patent Office, and then at that point they could make these substantive rules about what does inequitable conduct mean, and how should we treat that, and what effect should it have ongoing.
Right. Although, here it seems to me actually to sort of think about appropriate roles for the Patent Office and the courts, right? So. I think it's one thing to say on an issue of patent examination, we ought to grant the Patent Office substantive rulemaking authority, and they ought to have some power to determine what those things are. I'm all in favor of that. But I don't think that the Patent Office has any comparative advantage in talking about a bunch of issues that they're never actually going to see in practice, right? Setting en banc rules for damages. Setting en banc rules for the doctrine of equivalence, right? There are a bunch of things that the Patent Office just never encountered.
I think you're right. We see that when the Patent Office holds roundtables, the people who come to those are patent prosecutors and a few folks who are enforcing their patents, but there tends to be an absence of folks on the other side. So,
right. Now, I will say, I think there is at least some possibility that Microsoft versus I4I case, which is at the Supreme Court right now, which is nominally about the question of whether the clear and convincing evidence presumption of validity applies even to art that's not cited before the Patent Office, ends up being a vehicle to bring in a sort of stronger administrative law vision of the Patent Office and its relationship to the courts. I can imagine the court saying, clear and convincing evidence, preponderance of the evidence, those questions don't make any sense. We're talking about review of a decision by an administrative agency. We've got a set of standards for review of a decision by an administrative agency depending on the circumstances in which the agency acts. But those are court standards. Those have nothing to do with how we should be reviewing patent validity. And so if that happens, right, then I think we may actually be sort of moved into a world in which we have to think about these in administrative law terms, whether or not they're substantive.
Paul.
We had a posting from Hal Wegner a couple of days before I came out, referring to an English decision called Virgin on incomplete hits of parts, which the court didn't decide. And the reason why it didn't decide it was because it hadn't got the necessary facts, and the court exercised judicial restraint. So I wonder, in terms of thorough sense, whether you've reached a situation where the court has said, our previous rules from our precedents are so convoluted and mixed up that we cannot resolve this fact pattern without fundamentally considering everything. Therefore, we should put things over. If the court is not getting into that sort of mess, does it really have rule-making powers? In other words, surely the rule-making powers when the court's previous rules have got into a mess.
So I guess, as a matter of theory, right, the answer is correct. It can't do it just on the abstract. There's no power to grant advisory opinions. That said, I think what Ryan's talking about is kind of blurring the line a little bit. Right? So we could have resolved the question of whether Bilski was entitled to a patent, for example, without rewriting Section 101 jurisprudence. Right? So the issue was presented to the court. It's not an advisory opinion, but neither was it sort of a last resort opinion. Right? That is, and I think in Theracent's similarly, right, you could resolve the Theracent's case without asking the question, should we revisit all of inequitable conduct law? And indeed, one of the problems with Theracent's, as I think Lisa adverted to, is unless we are to abolish inequitable conduct law, this actually looks like a pretty good case for application of it, even if we're going to narrow it, because the conduct here is pretty bad. Yes, sir.
Professor Manel, you referenced your question in the noble review of Markman rulings, and I was wondering, are you suggesting that the district court decide the Markman interpretation and then no review, or are you suggesting the jury's jury?
Well, it is an area where I think, again, we have the Seventh Amendment coming up, and the Federal Circuit decided in 1995 that this is a question of law. The Supreme Court said it's a question for the court. There's tremendous consternation among district judges that, in fact, they have to learn a lot about the technology in order to resolve this question. And so we have, and in terms of my objective of speed, the good news when you lose in the district court is we got a really good chance on appeal. So we're not providing a lot of certainty for people in the inventorship world. The Federal Circuit, I think, is coming to believe that their jurisprudence is causing problems here. Several circuit judge members have said that they think they should essentially move away from the de novo review standard. Chief Judge Michel likes to say that they already have, they just haven't formally done it. But in any case, this is an area that I think has kind of risen. District judges are very vocal about it. Several members of the Federal Circuit have said they want to get rid of it. It doesn't mean they're not going to review. It just means that they will approach it with the kind of deference that they would other trial court decisions that involve a tremendous amount of effort by the trial court. We can call it fact-making or fact determination or not. So, from my standpoint, as just a kind of observer, someone who's done a lot of experimenting with judges in mock Markmans, I've come to believe that there's inherent subjectivity in Markman rulings. It would be better to resolve it earlier than later. And so, unless the Federal Circuit decides, as was proper in the Phillips case. The judge in the Phillips case made a mistake. She thought it was a means plus function claim when it clearly wasn't. And so, well, I don't know how clear it was, but I think most people think that it wasn't. So I think when you have a clear error, the Federal Circuit can review it and overturn it. When it's just an issue of, we can debate it. One of the things I hear from students of mine who clerked at the Federal Circuit is that what's happening is some judges there are deferring. Some judges are trying to show that they're smarter than the district judges. That's unhealthy in my view. I don't know that is happening. I'm just saying I've heard that. So I think that that's an area where if the Federal Circuit tomorrow were to say, we're now going to apply a somewhat more deferential approach, it would be a policy move on their part. It could have positive effects on certainty of trial court decisions.
Peter, I have a follow-up just to clarify what you said. The statement that just then that because this claim construction process is subjectively or inherently subjective, that is a question we should resolve early. And I don't quite understand it. I think I have it just about. Maybe you could explain that.
Well, when I first my working hypothesis when I started examining this question was that science is determinative, and so therefore claims, patent claims, like science, may be subject to some degree of predictability. People who look at it and study it will reach the same conclusions. Then I started doing this series of experiments. I've done about 12 of them with large groups of judges, bringing them in different rooms, having them hear the same arguments, and they tend to come out on a wide range of claims, between 40 and 60%, with varying degrees of confidence. I also ask the judges for confidence level, and I have high confidence on both answers. And the only determining factor that I have, and it's weak, is that sometimes when a particular lawyer who's really, really good makes the argument, he can get more of them on his side. So what I'm saying is that, in any complex patent case, you're going to have, 3 to 6 claim terms that can result in this kind of inherent subjectivity. It would be better if the district court, if they follow the general principles, are upheld. And that would communicate to the parties early in the process that running this up the flagpole to the Federal Circuit isn't going to be worth your time, if that's the only issue that you're appealing.
It also might cause us to wonder whether the sort of obsessive focus on patent claims is a really good idea, but that's another matter.
And that final point by Mark, I think we'll actually see some action on that point in the next decade, and that's something that there are a number of legal scholars who are aggressively thinking about our claim structure, and the emphasis that we're putting on that, especially as it relates to what we call the invention versus the claims, and when is there a disconnect in that regard. Now, Mark, your presentation was very interesting. I had kind of two questions, and maybe I'll just ask both of them, but they're totally different. One of them, right, you started off talking about eBay, and the eBay case is about injunctive relief. And in a large way, the patent community was divided on how they wanted that outcome. Right? There was a group of folks who believed and maybe because of their own economic interests wanted to have patent rights that you could always enforce with injunctive relief. And there were others who thought that wasn't so. And right, if we take those same groupings from kind of this political standpoint, how did they come out on Tomas's point about whether we should allow ongoing damages or not? Because I can see potentially two, right? I can see different arguments for how they might come out each way. And I don't know if you know about it, if this is already something true.
Well, I think it's actually a hard question, right? For a couple of reasons, right? One is there are some patent plaintiffs whose view is, don't give me an ongoing royalty, right? I want to be able to sue again on an ongoing basis. Now, I think that's usually because they expect one of two things to happen in the later suit. First off, right, the later, the previous suit's going to be res judicata as to validity and infringement. So it's only going to be a suit on damages. I think they expected going forward either you'll be a willful infringer and those damages in the second suit will get treble, or I'll get a shot at another jury and maybe I'll get an even larger number than I got this time. I'm not sure either of those things is true, right? That is, so Amato says not willful infringement, then that route seems to be over. So the question is, am I going to get a...
And a third point I would think is if ongoing damages are not allowed, it seems like it would be more likely that a court would award injunctive relief.
So maybe, although that's you got to play a pretty deep game as a plaintiff to be taking that position. And I haven't met anybody who says, yeah, please deny me money going forward because I think on the margins that will actually make it more likely that I'll get an injunction, which I can then use to leverage for, these are non-practicing entities after all, that I can use leverage for a higher settlement. I see the logic of it, but I think it's kind of too clever by half. I'm not sure actually sort of who ought to line up on the I want multiple suits side. It's certainly going to cost extra money. Patent litigators probably ought to line it, right? And maybe economics experts because they're going to do multiple trials.
And would there be a way for a court to also retain jurisdiction over the case and come back?
And that's generally what's happened, right? What's generally happened is you've seen an ongoing royalty, and the court says, report quarterly how many sales you have, and if there's a dispute, bring it to me.
Okay. And then it could almost be like a contempt type hearing, or.
Well, so I think that's right. If you're the hard questions, of course, under either scheme, right, whether you're doing subsequent lawsuits or not, or what happens when the defendant changes their product, either in an explicit attempt to design around what the patentee has done, or because they're changing the product, right? And so that's the TiVo EchoStar case, which is pending on the Federal Circuit right now, presents that question, right? Under what circumstances am I subject to the contempt authority when I make a failed design around attempt, something I thought was going to design around the patent, but which the court concluded did not.
And that makes sense. The second part of my question deals more with, would it be wrong to, instead of just asking the jury, what are the past damages, or are there past damages, what's the percentage, or what's the royalty? Couldn't we just ask them, are there past damages? Yes or no, what's the royalty? Are there ongoing damages? Yes, no, what's the royalty rate? And so
I think we ought to be expressly asking them that question.
Okay.
I think there's an interesting question if the jury gives very different numbers, right? Whether that's going to be supportable on a J-Mall, but you can imagine, right? Given that circumstances do change, that there's a story told in the trial that says, yeah, it wasn't that valuable in the past, but it's a lot more valuable in the future, or vice versa. This used to be really important, but now it's a minor feature of
right. And we have seen. And you can find some damage awards where it's not just a past royalty, but it's broken down by time periods when it became more or less important.
Right. So here's an interesting question that I have not yet heard anybody argue, but which I think seems a plausible argument for defendants. If what the jury awards is not a royalty percentage, but a lump sum number, I think it's a perfectly good argument from a defendant that lump sum number reflects the value of an ongoing right as well as a past right to use this damage, right? To use this product. That ongoing royalty should be zero. Right, because the jury has, just as if you sign a lump sum licensing agreement, right, and that wouldn't be for X number of years and then we'll start a royalty running thereafter. It's usually sort of for the full term of the patent. And that too, I think, argues for at least sort of having the jury specify, look, is this a royalty and is it ongoing, or is it, it's worth $500,000 or $500 million and that's it.
Right. And maybe that should be properly spelled out in the jury instructions, so there's no question. Other question, Greg?
So, a question for Ryan. I've always liked sort of when the Federal Circuit takes an issue on bond. I've always disliked when they list 18 things. Your thesis, so as sort of clarification, are you say it's more like an administrative agency due to rulemaking because of the long list of questions, because of the frequency of taking it en banc. And if it's because of the long list of questions, are there other explanations, like they just had to keep increasing the list of questions to get enough votes to get the thing on banc?
No, yeah, my thesis is based more on the sort of the number, and not necessarily the number, more of the breadth of the questions is what I'm concerned about. So one of the examples I give in the draft of my paper is from a area where they only ask 2 questions, but the questions are basically, do we have a rate restriction requirement, and if we do, why? And so, that's really the focus is how broad are the questions, how much of an impact is this going to have this matter of policy.
So what about the alternative explanation, though? I mean, they're not so much constantly thinking about being an agency making rules. That's just what it took to get votes.
I don't know. I haven't looked into, and I don't know if I can look into actually what was going on behind the scenes. When they circulate, when they do polling, one of the judges will say, let's take this en banc, let's send it around and take a poll. If they get enough votes, then it's fine. That's not available. So I don't know what was going on behind the scenes.
Let me just say that on this de novo review question that came up earlier, they're talking about that. Various federal circuit judges at conferences have said, we're actively debating that, and there's some issue that's holding them up. And in fact, they think that there's a majority, but there's at least 1 or 2, and I think I know who they are, who don't think there's the right vehicle. So that's kind of a way in which they can perhaps affect when it comes up and how it comes up, but they have kind of an internal dialogue that allows them to, in a sense, create the question.
But if they're held by Ryan's question, they don't really need the right vehicle, because any vehicle serves for the problem.
Well, although, I think the issue, right, I think there are circumstances of what Greg's describing, right? I think there were a couple of questions in the list in Phillips versus AWH, for instance, right, that were added basically to capture the interest of particular judges who didn't want to sort of resolve the question of what are the right interpretive sources for claim construction. They wanted to address the question of is there deference or not. But that actually leads to maybe you shouldn't be too worried about this even though they bother you, because as far as I can tell, having listed out a bunch of questions, they don't walk through them when they write their opinion, right? They often ignore a whole bunch of them. We all wrote our amicus briefs on these questions, but that doesn't mean that's what the court's actually going to write.
I think we're going to take one more question.
I have a question for Mark on this question of withheld injunctions, which is a very interesting area of law. Is there not an inherent jurisdiction in the court? If the court is going to withhold an injunction that it would normally grant, does it not have an inherent jurisdiction to regulate what's going to happen thereafter? Doesn't this give you an authority for setting a policy or otherwise regulating what's going to happen? Otherwise, the law is going to be in contempt.
Right. So I think that's a plausible argument. What Thomas Gomez argues, and I don't know that I entirely agree with this, is that it did not traditionally extend to prospective financial awards, and that whatever sort of ongoing supervisory authority you have to sort of grant a limited injunction and measure the scope of the injunction, it doesn't allow you to sort of grant an ongoing award. I can imagine you saying, well, if I have the power to enjoin the defendant, I can choose not to enjoin the defendant, but condition that on an agreement to pay a certain amount. I don't know that anybody's taken that approach, although I could see it happening. But
I think we're going to stop now. We have more to say, but let's give you a second.